with the permission of the chair, I would like to begin on Makar Sankranti, on this talk, which I have titled Hindus in Hindu Rashtra, 8th class citizens and victims of state-sanctioned apartheid. Ever since Mahatma Gandhi succeeded in controlling this nation's pulse, we have witnessed minority appeasement on an unprecedented scale, sometimes as virtue signaling, at other times as placation of victimhood. To illustrate but one instance of the extent to which the great Mahatma was committed to realizing his vision, while preaching to those affected by the pre-partition Hindu-Muslim violence, he urged, and I quote, "Hindus should not harbor anger in their hearts against Muslims, even if the latter wanted to destroy them. Even if the Muslims want to kill us all, we should face death bravely. If they established their rule after killing all Hindus, we would be ushering in a new world by sacrificing our lives," unquote. Every time I pass on a currency note, the same Mahatma sniggers at me, as though perplexed why I haven't yet sacrificed my life to usher in a new world. Well, the Mahatma need not snigger. His vision stands realized. The new world has indeed been ushered in. Right from the Khilafat movement to the cushioning of the Mopla massacre, to the Rangila Rasool incident, to blatantly discriminatory state and central articles and amendments, to school curriculums, to Hajj subsidy, to ignoring the Prohibition of Child Marriage Act, to Shah Bano, to the declaration by a sitting Prime Minister that minorities have the first right to resources. Every single time the minority has been appeased, it has only emboldened their leaders and political fronts for further extortion and blackmail. This has come at enormous cost, not only to their own community, but sadly also to the Hindus. But the question is not of appeasement. Yes, appeasement is discriminatory. Of course it is. But worse than appeasement is the active discrimination against the community not being appeased. Worse than appeasement of one community is apartheid against the other community. Truth be told, appeasement may rankle. Sure it does. But Indians have learned to accept it, even take it in their stride and scoff at it, for they realize the reasons for appeasements are political. And those reasons are placation of vote banks in order to win elections. And every political party, cutting across ideologies and religious affiliations or labels, indulges in appeasement. So while our Muslim population is 14.2% by the official census, as many as 31.3% of homes under the Awas Yojana, 33% of funds under the Kisan Samman Nidhi Yojana, and 36% of loans under the Mudra Yojana in the last 8 years have gone to Muslims. The BJP government has a Pradhan Mantri Shadi Shagun scheme exclusively for Muslim girls who complete their education, graduation before marriage. They will get rupees 51,000, no questions asked. Housing, skilling, scholarships, sarkari jobs, salaries to Maulvis. There is appeasement and preferential treatment meted out to the minorities by every political party, including the BJP. Heck, the BJP recently even offered Christian senior citizens a free trip to Jerusalem if they voted for it. Fact is, Ram Rajya and Rom Rajya are interchangeable, depending upon which way the wind is blowing. No, the issue, I repeat, is not of appeasement. The issue is of apartheid. The issue is of state-sponsored, state-sanctioned discrimination against a particular community. And that community is the majority Hindu community. This lecture concerns not appeasement, but apartheid. It concerns not dignity, but discrimination that is now so entrenched in our constitution, our policies, our legal framework, our society, our psyche, that they make Hindus not just second-class citizens, but rather eighth-class citizens. That this is happening in this so-called Hindu Rashtra is profoundly ironical. Here then, ladies and gentlemen, are 8 reasons why Hindus are 8th-class citizens in their own country. Number 1, state control of Hindu temples. State control of Hindu temples and their properties is by far the largest, financially most damaging scam of independent India. That it not only continues but flourishes under the Modi government is a sad reflection of how politicians in our country treat Hindus. Even using the petroleum sector as a cash cow pales in comparison to the loot and pillaging of Hindu temples. I don't know how and why. It is beyond the limits of comprehension of the flag bearers of secularism that if you truly believe that religion should keep out of state, the corollary is also equally applicable, that state should keep out of religion. But does it? Secularism is total separation of religion and state. Total. And yet there are half a dozen articles and amendments and directive principles in our constitution that make it plural, not secular. In fact, the word secular was inserted in our preamble by Indira Gandhi during the emergency. It was absent from Ambedkar's constitution. Our state declares itself to be secular, but is shamelessly not so, regulating, governing, and controlling as it does Hindu places of worship. Hindu temples have been, for thousands of years, the centers of worship, of learning, of community living, of trade and economy, of statecraft, even defense. And every invader has known that to dismantle India, you need to dismantle first this temple ecosystem. And every invader has managed it. What sets the British apart is that they managed also to pass this dismantling on to those who they ruled and subjugated. And now the latter are continuing with the dismantling. Right from the Madras Regulation 7, 1817 to the Religious Endowments Act 1863 to the Religious and Charitable Endowments Act 1925 to the Hindu Religious and Endowments Act 1927 to Act 12, 1935 to the Post-Independence Hindu Religious and Charitable Endowments Act 1951, Hindus have been at the receiving end of state-sponsored loot and pillaging of their places of worship. And when the 1951 legislation was challenged in the High Court, and subsequently the Supreme Court, and most of the draconian provisions of the 1951 Act struck down, the Congress that was in power then quickly passed the Hindu Religious and Charitable Endowments Act 1959, snubbing the court decree. 2 years ago, the Madras High Court dismissed a petition challenging the constitutional validity of this act, commenting that, quote, management of temples has got nothing to do with the right to worship. A Hindu can worship as much as he wants, unquote. But I ask you, if the Congress can bring in a legislation to control Hindu temples, one that still stands, why can't the BJP bring in a legislation to free Hindu temples? A petition by Swami Paramatma Nanda and Swami Dayanand Saraswati is pending in the Supreme Court since 2012, 10 years. They can allow midnight hearings for granting mercy to terrorists, but not here. In his plea, Swamiji gave the example of the grand Ardhanareshwara temple in Tiruchenagod, Tamil Nadu. Even though the temple generates more than 1 crore in annual income, the budget earmarked for conducting daily puja and performing rituals is a mere 1 lakh. Swami Dayanand Saraswati did not live to see the day his beloved temples would be wrested from state control. He passed away in 2015. Governments of just 10 states control more than 110,000 Hindu temples. Tamil Nadu temple trusts own 478,000 acres of temple land. Tamil Nadu government alone controls 36,425 temples and 56 mutts. For Karnataka, the figure is 34,558. Is this secularism? The communist state of Kerala has 5 Devaswam boards, Travancore, Guruvayur, Cochin, Malabar and Kudamankam. Together they manage 3,058 temples. The communists, for whom religion is supposedly the opium of the masses, are controlling Hindu temples and their boards, appointing board members on their whim and fancy. Many either belong to the Communist Party or are card-carrying members of it. Why? What business is it of the state to levy an administrative charge from anywhere between 5% to 21% on Hindu temples in the name of audit? What business is it of the state to dictate how many times a puja is to be conducted and who is to conduct it and who is qualified to be the priest and what is going to be the procedure for worship? What business is it of the state to control tens of thousands of acres of temple land and then send rent for it? The loss to Hindu temples on account of this itself is estimated over decades to be in lakhs of crores. According to activist and litigant T.R. Ramesh, the Tamil Nadu government that should be earning a minimum of 6,000 crores per annum from the 2.44 crore square feet of temple land it controls. It earns a mere 58 crores, not even 1%. Kapileswarar temple is one of the richest temples in Tamil Nadu, owning more than 600 acres of prime property in Chennai. State records show it has 473 defaulters, with most of its land now encroached. And this is just one state. And because of this loss in revenue generation, Hindu temples are not able to spend money on what they'd really like to spend money on. Opening up Ved Pathshalas, schools, colleges, goshalas, fellowships and scholarships, orphanages, Hindu cultural and religious centers, all things and causes that other religions and their places of worship spend their money on unencumbered. Only in India can you step aside and watch as the state appoints non-Hindus, Muslims like Fareed Hakim, Christians like Vangalapudi Anita, on boards that control Hindu temples. Only here will we remain silent as temple idols are stolen, temple property auctioned, a whole temple-driven ecosystem and way of life dismantled, bit by bit, brick by brick. Assault on temples has turned into an assault on Hinduism itself. Imagine a Hindu priest or a politician controlling and dictating how St. Francis Church or the Jama Masjid should be run. If that happens, perhaps our judiciary would indeed conduct a midnight hearing crying death of secularism. And the funny thing is, the very same turnips who call India a Hindu Rashtra are totally silent on state control of Hindu places of worship. They never stop to ask, how on earth is this secularism? You can provide Hajj subsidy for decades, use taxpayers' money to host grand iftar parties, fund AMU that has only 1.4% Dalit students and 0.25% Dalit teachers, plunder state coffers to pay monthly salaries to tens of thousands of Maulvis, ask government-run UGC to fund minority institutions that keep 50% seats reserved for Christians, step in to overturn a Supreme Court judgment just to appease Muslims, leech thousands of crores exclusively from Hindu temples, control tens of thousands of acres of Hindu temple land, spend hundreds of crores of taxpayers' money for the Kartarpur corridor. And all this is the state not interfering or succumbing to the demands of religion. All this is secularism. The great Mahakaleshwar temple, its revenue and realty, is tightly controlled by the state government through the Mahakaleshwar Mandir Act, 1982. From appointing pujaris down to even the size of the prasadam laddu. Tirupati's hundi collection since April 22 alone are rupees 700 crores. Now the government valuation of its properties is out. 7,123 acres valued at 85,705 crores. But secularism means this temple comes under the Religious Institutions and Charitable Endowments Act. Until a High Court order of 6 months ago, Andhra Pradesh Hindu Religious Institutions Act used to force temples earning 5 lakhs or more to pay 21.5% of their income to the endowments department, no questions asked or entertained. Now the state has issued orders to set up Dharmika Parishad with draconian powers to form temple trust boards and extend land lease. Is this secularism? More than 2 years have gone by since the Tamil Nadu government informed the Madras High Court that 11,999 temples under its control do not have enough money to perform even a single puja. But then again, I ask, largely overriding the Supreme Court verdict If the Congress can bring in a legislation to control Hindu temples in 1959, one that still stands, why couldn't the BJP, why couldn't Modi bring in a legislation to override it in the last 8 years? Why has the Modi government brought in even more Hindu temples under state control than was achieved by the previous dispensation? Why? Why does the Modi government gloat on constructing temple corridors like the one in Kashi at the cost of 350 crores when instead of offering this Kool-Aid to gullible Hindus, it could relinquish control over Hindu temples and allow the latter to fund hundreds of such corridors over the length and breadth of the entire country? As far as I'm concerned, bless you, as far as I'm concerned, a Hindu temple should be publicly listed as a company. After all, it supplies a product that people buy, peace of mind and reassurance. And unlike other companies that need to constantly refine or come up with better and newer products, a temple's product hasn't changed in a millennium and never will. Indians should be able to buy stake in the temple and make the temple richer. The richer it becomes through public trading, the more it will do for the society, schools, hospitals, roads, orphanages, pathshalas, housing, and the more it does for the society, the more it will garner donations. With the temple being publicly listed, the ready excuse of the Modi government that who will control the temple after we relinquish control becomes untenable. Let the government tax the temple's wealth, no issues. But at least the wealth generated by the temple will belong to the temple. At least then the Hindus will not be so blatantly discriminated against in their own country. The second reason. 2. The injustice towards Kashmiri Hindus. Terrorists are targeting Hindus settled in Kashmir, but not the Hindus visiting Kashmir. Tourist footfall in Kashmir this past year has been the highest ever since records began, a staggering 16 million. Business is booming. Registers are ringing. Tourists are safe. They want the Hindus to flee, but then return later as tourists. They want the Hindus to come as tourists and fill their coffers, but not settle in their own land. As Kashmiri Hindu and activist Sushil Pandit, himself a victim of ethnic cleansing, says, and I quote, "Tourism in Kashmir funds jihad. The Hindus are funding their own demise." Unquote. How on earth can we watch this unfold and not do anything about it? What kind of a country is this where one can settle 40,000 Rohingya Muslims in Jammu and Kashmir but not 7 lakh Kashmiri Hindus? There is no other way of saying it. We live in a nation of broken mirrors where you possess neither a shadow nor a reflection if you're a Kashmiri Hindu. We live in a nation that waits for death to rid us of our remembrances. We tell Kashmiri Hindus, please wait a little more, just a little more. 30 years have gone, but we haven't progressed from ugly, inhospitable transit camps that dot the Kashmir landscape at Sheikhpura, Natnusa, Veerwan, Vesu, Matan, Hall. In Anantnag's Vesu transit camp, Kashmiri Hindus who want to flee because they fear for their lives are being kept locked up under constant guard. They can't even step outside to buy essentials like milk and medicines. Is this the kind of freedom promised to the land's original inhabitants? While the Rohingyas enjoy unfettered movement in the near vicinity. According to the Home Ministry data, only 17% of the promised houses for Kashmiri Hindus have been completed in the last 6 years. Only 5,928 Kashmiri Hindus have been appointed through the Prime Minister's job scheme. The number of Kashmiri Hindu refugees is 700,000. A figure derived from the data provided by the government of Jammu Kashmir that says 83,216 families fled Kashmir in the aftermath of the Kashmiri Hindu genocide. 700,000 and 5,928. I shall leave it to the mathematicians among you to subtract this number from 700,000. To an extent, the Kashmir Files, the recent film by Vivek Agnihotri, has tried to reset the Kashmiri Hindu narrative. And that is why so many are rattled by it. Many prominent Kashmiri voices, the politicians, the intellectuals, writers, poets, all those who stayed silent even as the Kashmiri Hindu genocide unfolded right before their eyes, they called for a ban on the film. To them I ask, can there be reconciliation without remembrance? Crime without comeuppance? Can there be death without deliverance? Can there be justice without Nuremberg? Why do they want to hide the truth about the Nadimak massacre that the film truthfully depicts, where terrorist Zia Mustafa lined up 23 unsuspecting Kashmiri Hindus and shot them point blank? And as he was escaping, he heard a baby cry, and his comrade goaded, "Ye karnuwa chupe." And then the baby became the 24th victim. Why do they want to hide this? Why do they want to hide the truth about Girija Tiku, who was raped and cleaved in two by a mechanical saw while she was still alive? Why do they want to hide the truth about B.K. Ganju, who hid inside a rice barrel when jihadis came looking for him, after his Muslim neighbor informed on him? Ganju was shot dead. Rice laced with his blood was fed to his wife. Why do they want to hide the truth about slogans raised from mosques on 19th January 1990, Raliv, Saliv, Galiv, convert, run or die, death to kafirs, Pandits go but leave your women behind, Nizam-e-Mustafa? Why do they want to hide all this? And what is this other side of the genocide that they demand should also be shown? That Yasin Malik, assassin of Squadron Little Khanna, loved dum aloo? That Bitta Karate killer of 42 Kashmiri Hindus was the son of a shawl weaver? That Zia Mustafa, perpetrator of the Nazi-Mark massacre, was a compounder at a hospital? I will tell you why they want to hide this truth to be hidden. Because they realize that the Kashmir Files is not just a film. It is a Proustian collection of memories of Girija, of Ganju, of Dinanath, of tens of thousands of Kashmiri Hindus who were betrayed by their own friends. They might have taken away from the Kashmiri Hindus their home, but they can never take away from them their words. For their entrapment in a film may fool us into believing they have a physical form, a form that can be destroyed when the film is destroyed. But the words existed much before their prisons did. Words never die, never. They always survive. In times of terror, we wrap them and we hide them, like our ancestors did. And it may take 30 years or 300 or 3,000 for them to be uttered again, but uttered again they will be. And when they are, their words will echo in the valleys of violence where people only know how to light Molotovs. And these words will make them light diyas again. To be sure, I do not care about Islamists and jihadis and the politicians forgetting about those words. What bothers me immensely is that our government, our judiciary, our society has forgotten them. How can these pillars of our democracy forget those cries of Girija, those laments of Dinanath? How? Hearing them, those words, those haunting voices, one feels lost for hope, wondering whether that fabled arc of moral universe would ever bend towards justice for the Kashmiri Hindus. Remember that 3 years ago, the Supreme Court diabolically rejected reopening cases of criminal atrocities against Kashmiri Hindus because, quote, too much time had elapsed. That's correct. Justice is now weighed against time. A month ago, the same Supreme Court reiterated its previous stand, that of not opening cases of atrocities against Kashmiri Hindus. Governments come and go and we shout and we make 100 excuses, but we can't get away from the fact that Kashmiri Hindus are in exile. As Salman Rushdie expressed so poignantly in his satanic verses, and I quote, "An exile is a dream of glorious return. It is an endless paradox, looking forward but always looking back. An exile is a ball hurled high into the air. He hangs there, frozen in time, translated into a photograph, denied motion, suspended impossibly above this native earth. He waits the inevitable moment at which the photograph must begin to move and the earth reclaim its own, but it never does. When will that photograph begin to move? Mind turns numb at the very thought that this nation, we are going about our business for 30 years while 500,000 Hindus have been reduced to refugees in their own land. Is this what a so-called Hindu Rashtra is supposed to do for Hindus? We are the only country in the world that allows this, across parties, across governments, right or left or center. 3 years to 2019, 3,686 law and order incidents occurred in Kashmir. 3 years since 2019, the number is only 430. Terror attacks have reduced by 40% since 2018. But then why is it that only 5,000 Kashmiri Hindus have been brought home? And of those few who have been, more than 25 have already lost their lives. Making Kashmir files tax-free was a great idea, but remember, your dharma. It is not to make a film tax-free. It is to make sure 7 lakh Kashmiri Hindus are brought home. Time is running out. Time is running out. A refugee accepts his fate and the humiliation that comes along with it. For he must worry about his new life. He forgets how to complain, and that is a fatal mistake. Arundhati Roy, that totem of the left, once cushioned the crimes of the Maoists by calling them Gandhis with guns. Well, Kashmiri Hindus are the Gandhis without guns. And that is the singular reason why no one cares for their plight. Because this nation hears complaints through the barrel of a gun, not the ink of a pen. This nation believes inaction is a medicine. It believes time heals. It believes wounds do not fester. It believes the exiled never returns. This nation waits for death to rid its people of their remembrances. This nation wishes the Kashmiri Hindus all happiness and joy in the afterlife. Kashmiri Hindus are the Jews, but unfortunately, India is not Israel. They call Kashmir the Switzerland of the East. Wrong. It is the Srebrenica of the East. And it will remain so till such time every Kashmiri Hindu is returned home. The third reason. 3. The Waqf Act 1995. Waqf is the third largest landowner in India after defense and the railways, with much of its land holding rather amusingly pre-independence, an endowment of the insidious give and take between the British and the Muslims they desired to pacify. Indeed, many of the Waqf land holdings go as far back as 1857. 77% of Delhi is on Waqf land. I had to really practice repeating this Waqf time and again. I didn't want to make a mistake there. Including the Delhi High Court. Central Vista, that has recently been renovated and on whose hallowed turf new government buildings will shimmer and glisten, is on Waqf land. CGO complex, Jawaharlal Nehru Stadium are on Waqf land. Only 3 things are certain in an Indian's life: death, taxes, and that knowingly or unknowingly he ends up walking every day on Waqf land. Over time, many of these Waqf properties were taken over by the government, but then inexplicably, or perhaps not, one of the last decisions of the outgoing UPA government in 2014 was to gift 123 prime central Delhi properties to Waqf and withdraw its claim on them. These prime real estates properties are from the time of our independence and were endowed to the government by the departing British. Their status remained unchanged for 70 years until March 5, 2014, when the departing Congress decided to endow them to the Waqf. Even the High Court judges have opined that Waqf land is Allah's and Allah's alone, and that the government cannot be the owner of this land. It is not just government buildings that the Waqf claims to be its properties. Mukesh Ambani's house is on Waqf land. It is worth checking whether this hall where I am delivering this lecture, is also a Waqf property. Allah is all merciful, please check. The Waqf board lays claim to 354,913 estates and 866,035 properties comprising 802,000 acres of Indian land, with UP having the highest share of 213,833 Sunni Waqf board properties and 15,386 Shia Waqf board properties. हिंदू मुस्लिम गंगा जमुना यूनिटी तो बाद में संभाल लेंगे, यहाँ तो जमुना भी शिया सुन्नी में अलग अलग बट गई है. This data, by the way, is from the Waqf Management System of India, whose motto, if you visit their website, is once a Waqf, always a Waqf. Hold your horses, you Hindutvawadi Islamophobic bigots. You will, if you were to dig deeper, find that this grandiose motto is not the idea or thinking of the Waqf board or any of its members. It is, in fact, the verbatim exclamation of the Supreme Court in its 1998 judgment, case number 4372 SCR 398. Once a Waqf, always a Waqf. And the name of the honorable judge who said this iconic line, I'm not joking, Justice Dr. Anand. Allah is all merciful. Waqf essentially means that any donated property belongs to Allah in perpetuity. Waqf decides any property adjudged by Muslim law as pious, religious, or charitable, and therefore fit to be labeled as Waqf. In other words, Waqf is inalienable and irrevocable. If you think this is a figment of my fertile imagination, let me quote directly from a Waqf board document, quote, Waqf is a voluntary, permanent and irrevocable dedication of a portion of one's wealth in cash or kind to Allah. Once a Waqf, it never gets gifted, inherited or sold. It belongs to Allah and the corpus of the Waqf always remains intact. The fruits of the Waqf will be utilized for any Sharia compliant purpose, unquote. The Waqf boards are, in case you were wondering, headed and constituted exclusively by Muslims. If that wasn't discriminatory enough, let me run you through some sections of the Waqf Act 1995. Section 4 bestows on the Waqf property survey commissioner the authority and power like that of a civil court. Besides, the entire cost of the surveying is to be borne by the state. So, in a sense, a Hindu's property once declared as Waqf property, wholly arbitrarily, will be surveyed by Waqf, and the cost incurred on this count will be paid for by the Hindu taxpayer. And people say we are living in a fascist Hindu Rashtra. Kyun mazak kar rahe hai yaar? Section 40 gives the Waqf power to decide if your land is Waqf or not. In fact, if your property is laid claim to by Waqf, it is your responsibility to disprove its claim. And till such time you disprove it, it is Waqf land. Quote, where the board has any reason to believe that any property is Waqf property, the board may hold an inquiry in regard to such property, and if after such inquiry, the board is satisfied that such property is Waqf property, call upon the owner either to register such property as Waqf property or show cause why such property should not be so registered as Waqf property, unquote. Section 54 gives the Waqf the, the power to declare you an encroacher. Quote, whenever the chief executive officer considers whether on receiving any complaint or on his own motion that there has been an encroachment on any land, building, space, or other property which is said to be Waqf property, he shall cause to be served upon the encroacher a notice specifying the particulars of the encroachment and calling upon him to show cause before a date to be specified in such notice as to why an order requiring him to remove the encroachment before the date so specified should not be made, and if after considering the objections received during the period specified in the notice and after conducting an inquiry, the Chief Executive Officer is satisfied that the properties in question is Waqf property and that there has been an encroachment, he may make an application to the Waqf Tribunal for grant of order of eviction for removing such encroachment and deliver possession of the land, building, space or other property encroached upon the Waqf. The tribunal, upon receipt of such application, will make an order of eviction directing that the Waqf property shall be vacated by all persons who may be in occupation thereof by any part thereof, provided that the tribunal may, before taking an order of eviction, give an opportunity of being heard to the person against whom the application of eviction has been made. If any person refuses or fails to comply with the order of eviction within 45 days from the date of affixure of the order, the Chief Executive Officer or any person duly authorized by him in this behalf may evict that person from and take possession of the Waqf property. समझ में भी कुछ नहीं आया और सुन के भी अच्छा नहीं लगा. So let me get this straight. The Waqf decides in its wisdom that a property is Waqf property. It then serves a notice to the encroacher. Subsequently, it takes the matter to the Waqf tribunal, headed by all Muslims. And the tribunal decides on the nature of the said property and orders eviction. The terror continues paragraph after paragraph, section upon section. Let me read out section 85, bar of jurisdiction of civil courts. Quote, no suit or other legal proceeding shall lie in any civil court in respect of any dispute, question or other matter relating to any Waqf property or other matter which is required by or under this act to be determined by a tribunal, unquote. Bravo. In fact, even the Supreme Court declared in 2019 that a civil court in India has no jurisdiction in the matter of a suit pertaining to a Waqf property. Let me remind you of the ground reality. All this legalese is fine, but the ground reality is that Waqf tribunal decision can only be overturned by a long and financially draining legal process. That is only possible in the recent times. Earlier, you couldn't even do that. The Waqf knows this. In a country where 40 crore cases are pending, harassment through legal procedure that stems from the inner offices of an all-appeasing government, executive and judiciary, is a sword that is sharper and more potent than Khalid's. How, one may then ask, has the Waqf Act 1995, that is patently unfit to be applied to leave alone a mental asylum, has been applied to a nation of 1.3 billion people, assuming the two are not one and the same? Remember, there is nothing in the act that safeguards the religious properties of Hindus being appropriated by the Waqf. This itself violates not only the principles of natural justice, but also multiple articles of our constitution beginning from 14, 15 and 25. In fact, BJP's enfant terrible, Ashwini Kumar Upadhyay, who will figure a lot in my lecture, recently filed a petition in the Supreme Court challenging the validity of the Waqf Act. His plea was that the Waqf board has Muslim MPs, MLAs, legislators, civil servants, lawyers, scholars as its members, and they are remunerated by the taxpayer, even though the state doesn't collect money from mosques. How is this secularism, he asked. The Supreme Court refused to entertain the plea and threw it out. The judge called the petition, quote, abstract. That judge is now and will remain for the next many years the Chief Justice of India. The mayhem continues. Here is section 28 that outlines the power of the district magistrate, additional district magistrate and subdivisional magistrate to implement the direction of the Waqf board. Quote, subject to the provisions of this act and the rules made thereunder, the district magistrate or in his absence an additional district magistrate or in his absence a subdivisional magistrate of a district in the state shall be responsible for implementation of the decisions of the board which may be conveyed to the chief executive officers, and the board may, wherever it considers necessary, seek directions from the tribunal for the implementation of its decisions, unquote. What was it that one of the main protagonists of Vivek Agnihotri's film said? गवर्नमेंट भले ही इनकी हो, सिस्टम तो हमारा है. वेल, सिस्टम ही नहीं, यहां तो डिस्ट्रिक्ट मजिस्ट्रेट, एडिशनल डिस्ट्रिक्ट मजिस्ट्रेट, सब डिविजनल मजिस्ट्रेट भी हमारे लगते हैं. दिल नहीं भरा लगता आपका. Well, here then is section 107. Now, in law, there is something called the statute of limitation. That is, the time period for acting on a dispute or filing of a suit is set by law. And this law is enacted through the Limitations Act 1963. But wait, section 107, quote, Act 36 of 1963 will not apply for recovery of Waqf properties. Nothing contained in the Limitation Act 1963 shall apply to any suit for possession of immovable property comprising in any waqf or possession of any interest in such property, unquote. What this means is that the waqf can lay claim to and recover any property it wishes to without having to worry about the passage of time. After all, time hai kya? The waqf, as you would have realized by now, is a parallel government, wholly sanctioned by our own government. It has, through its overarching board, its own legislature, through its surveyors and estate and compliance officers, its own executive, and through its tribunal, its own judiciary. And through this act, through its application, a message is sent to every citizen of this country. We are a special people. And that message is all pervasive and uncompromising. And it is this message that allows Muslims, even rational and logical and educated Muslim, to claim that the Gyan Vyapi mosque built atop the grand Kashi Vishwanath temple is on Waqf land. So, was the grand Kashi Vishwanath temple demolished by the genocidal monster Aurangzeb, and as confirmed through his own certified biography, Masir-e-Alamgiri, also on Waqf land? Is this the message that allows Muslims, even rational and logical and educated Muslims, to claim that the 1500-year-old iconic Manandiya Vali Chandrasekhara Swami temple in Tamil Nadu is on Waqf land? I ask you, how can a 1500-year-old Hindu temple be adjudged by Waqf to be on Islamic land when Islam is only 1300 years old? How? गंगा जमुना तहसीब बोल बोल के गंगा भी ले ली और यमुना भी ले ली. The more you read on Waqf, the more you realize that bulk of its muscle is flexed not only through the draconian Waqf Act, but also through a letter that Prime Minister Indira Gandhi wrote during the emergency, ordering all states to strictly obey her diktats. If the Waqf properties, she wrote, have gone into adverse possession of state government departments, the Waqf board could well start legal proceedings against the concerned departments. And where costly buildings have been put up by the state on Waqf land and their vacation is not feasible, the state government may enter into permanent leases with the Waqf board after paying to the board the bulk of the market value as premium. I understand, she further wrote, that Waqf boards have sent your governments lists of Waqf properties in the possession of government departments. Please see that these are dealt with as suggested above. A periodic review should be undertaken and a monthly report sent to me. Waqf, as ordained by the committee and as agreed to by the center, should be treated differently from individual landlords and therefore exempt from the Rent Control Acts. The Waqf only asked the Congress to bend. The Congress decided to crawl. In fact, during the dying days of the UPA, the Waqf Properties Eviction of Unauthorized Occupants Bill 2014 was tabled in the Rajya Sabha, giving draconian and overarching powers to the Waqf eviction officer to demolish whatever it considered as an encroachment of Waqf property. I am sorry, Yogi Adityanath ji, but read this bill. It is the humble Waqf estate officer and not you who is the original bulldozer Baba. Through this tabled bill, Not only was every order made by the Waqf estate officer to be considered final, it could also not be called into question in any original suit or application, and no injunction could be granted by any court against it. But things didn't just stop at injunction. The bill barred any Indian court to have jurisdiction to entertain any suit concerning the eviction of any person from any Waqf property or demolition of any structure or fixture from any Waqf property. ये लिखता कौन है ये ऐसी legalese? I would really love to meet that guy. Luckily for us, encroachers of Allah's land and that hard Congress went away in 2014 and was replaced by the soft Congress. Appeasement continues, if not through this draconian bill, at least in the interim through the 1995 Act. That the Waqf Act 1995 is blatantly communal, discriminatory, unconstitutional and draconian is not in contention. One only must read its clauses, and I've read a few, and sections to realize what a rotten hand Hindus have been dealt with through this act. What adds to the absurdity is the fact that this is now a perpetual motion machine, gobbling up land, property, and government largesse with speed and stealth. 10 years ago, the Waqf owned only 400,000 acres. Now it's 800,000 acres. With every passing day, it is insatiable in its appetite, as though out to prove Dr. Ambedkar and his profound prophecy of Muslims under divine obligation to convert Dar al-Harb into Dar al-Islam. It is no longer an arcane endowment that is centuries old. It is an ever-growing mutant, having perfectly adapted to the appeasing and virtue-signaling state. The Hindus who, during the partition, fled what is now Pakistan and came to India, their property out there was promptly confiscated and either distributed to the Muslim citizenry or taken up by the government of Pakistan. Not so the case with Muslims who from India went over to Pakistan. Their property was handed over to Waqf. And as a result, the Hindu refugees who came to stay on this land are paying rent that is subject to arbitrary increases. And the injustice continues. Hindus must now beg for Waqf land to celebrate their festival, as is what happened recently in Karnataka. This when the governments of both center and state, as I said, have usurped hundreds of thousands of acres of temple land and are responsible for more than 110,000 temples losing lakhs of crores in rental incomes. There is no such act for Hindus. There is no such act for Sikhs. There is no such act for Christians. There is no such act even for Muslims in Muslim majority countries like Turkey, Sudan, Egypt. Welcome to the Islamic Republic of India. This is not our future. This is now our present. The fourth reason, the RTE Act. Number 4, the RTE. All religious schools are equal, but some are less equal than others. This paraphrasing of George Orwell's parodic commandment typifies the thinking of the state when it comes to Hindu-run schools and educational institutions. The Right to Education Act, or the RTE, is the proverbial Moses staff that makes sure this commandment is obeyed. The RTE in itself is a worthy undertaking that states as its preamble, quote, an act to provide for free and compulsory education to all children of the age of 6 to 14 years, unquote. But in terms of discrimination, at once casual and concrete, very few acts match up to the RTE. The act was passed, of course, by the Congress-led UPA back in 2009. Tellingly, it remains in force in the present-day fascist Hindu Rashtra. As the saying goes, Sarkar bhale tumhari ho, system to hamara hai. Simply put, the RTE has and continues to destroy Hindu schools and institutions, Perhaps that is the overarching goal of secularism, to allow the prospering of every other religion, its belief systems, its way of life, its cultural values, its educational methods, its wisdom, its books and scriptures, except Hinduism. And after Hinduism is dead, we will remember it fondly and exalt its glory like we do for every other extinct civilization and culture. This is what is taxidermy fetish. There are numerous provisions under the RTE that selectively apply only to non-minority schools. Like, for example, you cannot have a capitation fee or screen students you want admitted. The reimbursement of fee by the government is never timely, forcing the school to go under debt, even shut shop. You would have to have a government-mandated selection procedure for teachers, one that includes a quota-driven recruitment. There are several building and infrastructural restrictions and requirements that a school must comply with. The list is endless. But the overarching draconian provision of the RTE that is proving to be a death knell for privately run Hindu educational institutions is its order that 25% of the seats must be allotted to children belonging to the economically weaker sections, or EWS, and other disadvantaged groups. This does not apply to minority schools. So the onus of serving the economically weaker section of our society rests solely on Hindu-run schools and not on Muslim or Christian-run institutions. In 2017, 3 years after the heralding of the fascist Hindu Rashtra, the National Independent School Alliance, NISA, compiled a list of schools in 12 states that had been asked to shut down by the governments for non-compliance to the RTE's draconian provisions. And as the RTE primarily applies to non-minority schools, one can safely assume these were Hindu-run schools. As many as 7,000 schools in Maharashtra alone, the bastion of Hindavi Swaraj, the keeper of the Hindutva flame, had been told to shut down. We need to understand that the threat of closure doesn't just intimidate the school, it scares the pupils and the parents too. It has been 5 years since NISA implored the center to relook at the RTE and ease the draconian anti-Hindu strictures. The Hindu Rashtra government is silent. Now, as the famous lines go, जिसका कोई नहीं उसका तो खुदा है यारों, ये मैं नहीं कहता, किताबों में लिखा है यारों. Which book, you may ask? Well, in a secular nation, we only have one book to fall back on. So let us look at our constitution. Because if discrimination is cast in stone, we must at least examine the stone. The stone, to begin with, is Article 30. I now quote verbatim. Article 30, 1. All minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. 1A. In making any law providing for the compulsory acquisition of any property of any educational institution established and administered by a minority referred to in Clause 1, the state shall ensure that the amount fixed by or determined under such law for the acquisition of such property is such as would not restrict or abrogate the right guaranteed under that clause. 2. The state shall not, in granting aid to educational institutions, discriminate against any educational institution on the ground that it is under the management of a minority, whether based on religion or language. I'm wondering if the same guy who wrote the Constitution also wrote the Waqf Act is as difficult to understand. But a direct fallout of not only the stricture of this article, but its words and composition is that Muslims, a majority in Kashmir, Sikhs, a majority in Punjab, and Christians, a majority in Nagaland, are still considered minority and can run their schools that will not be subject to the RTE. What's going on here? Let us now look at the toothless Article 28. Toothless because both the central and state governments have discovered enough loopholes in it to violate this article at will to placate their vote bank. The article states, 1, no religion instruction shall be provided in any educational institution wholly maintained out of state funds. 2. Nothing in clause 1 shall apply to an educational institution which is administered by the state but has been established under any endowment or trust which requires that religious instruction shall be imparted in such institution. 3. No person attending any educational institution recognized by the state or receiving aid out of state funds shall be required to take part in any religious instruction that may be imparted in such institution or to attend any religious worship that may be conducted in such institution or in any premises attached thereto unless such person, or if such person is a minor, his guardian has given his consent thereto, cultural and educational rights. Couple this with Article 26 of our Constitution that ordains, please bear with me because if I had to suffer this, I want you to suffer this as well. छोड़ूंगा नहीं, मैंने ये पढ़ा है तो. Article 26, quote, freedom to manage religious affairs subject to public order, morality and health, unquote. And that, quote, every religious denomination or any section thereof shall have the right to establish and maintain institutions for religious and charitable purposes, to manage its own affairs in matters of religion, to own, acquire movable and immovable property, and to administer such property in accordance with law. Couple this with Article 26, 28 and 30 and read both articles side by side and you will realize what you're up against. But I run ahead of myself because let me now read clause 5 of Article 15 of our Constitution that was brought in by the UPA in 2006 as the 93rd Amendment. In Article 15 of the Constitution, after clause 4, the following clause shall be inserted, namely 5. Nothing in this article or in subclause G or clause 1 of Article 19 shall prevent the state from making any special provision by law for the advancement of any socially or educationally backward classes of citizens or for the scheduled castes or the scheduled tribes insofar as such special provisions relate to the admission, to their admission to educational institutions, including private educational institutions, whether aided or unaided by state, other than the minority educational institutions referred to in clause 1 of Article 30. Now, Article 15 that prohibits discrimination on grounds of religion, race, caste, sex, or place of birth already had clause 4 that allowed states to make special provisions for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and scheduled tribes, but it did not exclude minority institutions. And that put the onus on the minority to also contribute to the society and work towards the upliftment of our socially and educationally backward classes of citizens or for the scheduled castes and scheduled tribes. And I'm sorry, this was unacceptable to the Congress, as well as, I must add, the BJP, because this amendment was passed with the latter's support. I hope you can see it very clearly now that it is this 93rd Amendment which is the staff meant to establish the commandments of Article 26 and 30. And it is because of the brandishing of this staff that the RTE does not apply to minority-run schools, barring a ubiquitous exception of a ban on corporal punishment that all Indian schools must of course compulsorily follow. To summarize the chain of events, the government applies RTE rules selectively to Hindu-run schools, orders them to maintain a 25% EWS quota, doesn't provide fee reimbursement on time, so much so that back in 2019, as many as 4,000 schools threatened to go on a strike against delays in fee reimbursement. And unconcerned, the government threatened the schools and blackmailed them with land occupancy provisions just to escape paying the reimbursement. The schools are forced to hike fee for all pupils in order to escape debt and closure. The fee increase forces Hindu parents to shift their children to other schools. more and more Hindu parents take their children away from Hindu schools, and these children are then welcomed by schools run by minorities. And by virtue of the religious obligations and directive principles of the constitution laid down for the believers, where preaching, proselytization and conversion are religious duties, these children, Hindu children, are inevitably, sometimes subtly, sometimes directly, put under pressure to convert. Meanwhile, the Hindu school is forced to close down. A recent report estimates that the RTE is responsible for the closure of more than 10,000 Hindu-run schools. A 2017 CAG report noted that the release of funds by the center to schools was sometimes delayed by as much as 307 days, almost a year. Such delays not only lead to outright closure of schools, they also result in abandoning any plans for expansion or upgradation of infrastructure. Ironical, because these are the criteria to be fulfilled by schools under the RTE. More importantly, even if the government pay the EVS pupil fee, albeit a year late, the school would still have to shell out for textbooks, uniforms, transport and other ancillary things every school-going child needs, especially when his parents are cripplingly poor. The authority that decides if a school is exempt from the RTE is the National Commission for Minority Educational Institution, NCMEI. This body, although is quasi-judicial in its directives, cannot have a Hindu as its member. In fact, the same enfant terrible BJP leader Ashwini Upadhyay filed a PIL. Kitni PIL file karoge? Sarkar tumhari hai. He filed a PIL seeking to challenge the NCMEI, the Act, and to allow Hindus to be declared as minorities in states and union territories where they are, well, minorities. This is logical and rational, especially because it has wide-ranging repercussions on the survival of Hindu-run schools in these states and union territories. Hindus are now a minority in Jammu and Kashmir, Mizoram, Arunachal Pradesh, Manipur, Punjab, Nagaland, Meghalaya, Ladakh and Lakshadweep. But one entity has opposed the BJP leader's petition, calling it frivolous. No, that entity was not the Congress or the Church or Darul Uloom. That entity was the BJP central government. The BJP leader's own government called his petition, quote, untenable and misconceived in law, and told the court that the petition was, quote, not in larger public or national interest, unquote. The center, led by the Hindutva forces, backed by the same discriminatory National Commission for Minorities Education, NCMI, under whose act only Muslims, Christians, Jains, Sikhs, Buddhists and Parsis are listed as minorities. Following widespread outrage, the Modi government has only now asked more time from the court to rethink on the matter. Meanwhile, Hindu-run religious and linguistic schools continue to close under the burden of discriminatory RTE rules. The BJP leader Ashwini Upadhyay lamented, हमें तो अपनों ने लूटा, गैरों में कहाँ दम था, मेरी कश्ती वहीं डूबी जहाँ पानी कम था. But मैं अश्विनी जी की दाद दूंगा, he has not switched over to Congress. So, if there is only one thing more cruel than not allowing Hindu temples to run their own educational institutions without fear of state intervention and control, it is not allowing Hindus to run their own educational institutions without fear of state intervention and control. And if there is only one thing more cruel than the fact that both these cruelties are being subjected on the Hindus, it is that they are being subjected by the Hindus, belonging to a Hindu government in this Hindu Rashtra.